Thanks, Alison. I think I'm going to go first. First of all, it's nice to see everyone on screen, although it is, of course, not as good as in person. I'm not a fan of too much screen time, so I hope we can make some succinct but really important points about children in care and contact applications at the moment. And I will do this as concisely as I can, given how long we've been on screen so far. I have some PowerPoints which set out the legal framework, which remains the legal framework. There has been no change to Section 34 by virtue of the Coronavirus Act 2020. We have, of course, seen some guidance. I won't go through those in detail because you'll be familiar with them, and we will be able to send these to you if you need them at the end of the meeting, and you can always contact our family clerks at familyclerksgclaw.co.uk. I just want to first of all start with this and why I wanted to talk about children in care and in foster care at the moment. The government guidance that came out in April when the social distancing came out at the same time said this to local authorities and social workers: we expect that contact between children in care and their birth relatives will continue. It is essential for children and families to remain in touch at this difficult time. And for some children, the consequences of not seeing relatives would be traumatizing. And I just want to focus on the traumatizing point, because it's been my experience anecdotally that so far, for children away from their families, away from potentially siblings as well, they've been seeing their parents, their mummy or daddy regularly, and suddenly life has changed dramatically overnight and they're not having that direct contact anymore. They might not be of an age to fully understand why it is that they're placed with essentially strangers, their foster carers, not their natural family anyway. They now face unknown delay to when they'll have a determination of their Article 8 rights. And alongside that, they no longer have that sense of security of seeing their mum or their dad, who they'd previously been seeing on a regular basis. My understanding is that very few local authorities, and it's no criticism, have been able to facilitate direct contact. I have, and my MP actually has written to the Department of State, for the Minister of State for the Department of Education, to try and find out exactly what the national picture is in terms of contact for children in care. And if anyone is interested in that response, then please do contact me directly, because it's something I feel quite passionate about. I know how individually people feel anxious about COVID-19 and how uncertain life looks for so many of us as family members lose vocations, jobs, etc., etc. So I just really pause and think about children in care, placed with foster carers, not knowing what will happen to them in the long run, not having any decisions about permanency, but also not able to see the very person that they might really need to see at the moment. And I really wanted to do this talk and go through this with those that are attending this meeting, because about 3 weeks ago, a solicitor did make a Section 34 application for direct contact in a care case that I was involved in, and it was met with some success. And I just thought it was helpful for people to know that, because I think that we have tended to think that, well, there can't be direct contact at the moment because of social distancing. A key factor in that case was this, which was that children who are in foster care and looked after are going to school, as key worker children are, alongside children who meet other specific needs, including if they're children who are in care. If they're going to school on a daily basis, they are being exposed to any number of other children and the people that they're exposed to. They're also being exposed to between 10 and 20 different members of staff, because schools are not necessarily providing the same teachers every day. They're running a rota, so different teachers are coming in and out of that school setting every day. So when we've looked initially at risk and thought, well, we mustn't risk the placement, we can't risk anything further for the children, well, actually, they're already, if they're going to school and if they're in care, they must be going to school, except for in certain circumstances, exposed to a range of adults. So then it means we can look more closely about whether there is some provision that would enable the child to see a parent who is exercising and agree to exercise social distancing measures. And it was really that factor which made the judge stand back and think, what's the risk to the children? What's the statutory test? I need to look at the welfare of these children. It's for them, and clearly they need to see their mum. It's in their best interest. These were children who'd lived with their mum for the entirety of their life. She was a single parent, and they really could not understand why they were no longer able to see their mummy. I've got on the screen in front of me really the domestic law duty that reflects what ECHR law says as well about the importance of contact for children in care, that it's one thing to take a child away from their natural parent, and when you do that, you have to very strictly limit any further incursion into their Article 8 rights, which we're all familiar with. Contact with a father is just as important as contact with a mother. And this still remains one of the leading authorities on why contact is important for a child who is in care and subject to a care order, to allow a child to know that their parents love them, to minimise the damaging sense of loss and abandonment. And of course, those things ring true at all times, and if not more true during this time of great anxiety for everybody. This is the guidance I set out that I quoted at the start of this talk about what the government expected. We expect that contact between children in care and their birth parents will continue, and its essential nature, and how traumatic it will be for children to lose that contact with natural parents and family. I'd say all of this very carefully because I recognise that nobody wants any social workers or any contact centre workers to be placed in any more danger that we ourselves would expose ourselves to, or a judge. And of course, any contact has to be supervised in a setting that is safe for everybody. But we do know that contact is happening and can happen for some children safely, and that there are ways of thinking about this to meet the particular challenges, whether it's PPE for social workers, whether it's in a certain setting that's safer. And I've just flagged here the emergency funding, which is to support the most vulnerable in society. Again, it's not clear in that guidance who that is available to, and I've asked my MP, and he has written to the Secretary of State for the Department of Education to find out what is in place to support children so that they can see their families at this difficult time. And of course, the ground is the framework, if you like, of day-to-day living is changing all the time. There may be further announcements this weekend about a relaxation on the social distancing measures. And having made this Section 34 application and really thinking about how this must feel to children at the moment, for whom, whereas a week might fly by for me, a week may feel like an eternity to an 8-year-old who's desperately missing their mother or dad or sibling, that we really need to be proactive in all of our cases in thinking about, can this child actually see their parent now? Are they being traumatised? What should we be doing about it as practitioners? We have the tools, and I think we just need to keep on being bold about making sure that we use them. And on that note, I will hand over to Mai-Ling. Thank you.
Thank you very much, Rebecca. Now, I won't keep you very long. I've noticed what the time is, and I've also just received a text to say my dinner's ready. So I'm not going to be very long. Slightly tangential to what Rebecca was talking about, I wanted to really think about what contact was like for parents and children during assessments at the moment. As we've heard, a number of the question about whether or not final hearings can go ahead and in what form they should go ahead means that lots of final hearings have been adjourned, but what we're still seeing is case management, lots of proceedings being issued, and also case management hearings going ahead. And in those case management hearings, of course, there are Part 25 applications with proposals for assessment. And I've yet to see in any of those Part 25 applications a really adequately laid out proposal of how an expert is going to assess either the parents or the children under the current restrictions. I've heard lots of people saying, well, could be various video or telephone or meetings in the park, but actually not really a really thoroughly thought out plan about what work can be undertaken now under the current restrictions and what work might be put off until after the restrictions are lifted. And what we've seen is that a number of experts, and I think the question mark we have to have in our head as we are thinking about what are the appropriate expert assessments or parenting assessments to direct at the moment, is firstly that a lot of expert opinions sort of divided. Some experts are taking instructions and other experts aren't. I think we have to think quite carefully about how a psychological assessment, for all of the reasons that we've heard about why parents can't participate fully in proceedings, as to whether they can fully participate via a smartphone in a psychological assessment. And I do know that some psychiatrists are still saying they can undertake assessments. And I think that's important for two reasons. Firstly, because if we just press on ahead, ordering assessments and assessments being undertaken in an unsatisfactory way, that's going to cause delay. And what we do know is that once the restrictions are lifted, there's going to be a bottleneck anyway of final hearings. So I think careful thought needs to be given for the timetable for assessments at the moment. And also, as I say, in terms of the proposals. And I think in terms of parenting assessments and whether or not, to what extent some of the work can be done now, some of the work, particularly observations of children and parents with children, which are obviously key factors. I had a suggestion the other day that parenting assessment could take place and that there could be observations in the park of the parents and the children. Now, I think going to the park at the moment is a pretty unreal experience for anybody, let alone for someone participating in a parenting assessment being observed by a social worker. So I think very careful thought needs to go on at the moment about how these assessments are going to be undertaken. I think, as Rebekah said, I think we need to do some very creative thought as to how they can be. Local authorities are sometimes offering their offices, and as we know, there's going to be more testing of key workers, and there are proposals, as I understand, for more contact centres to be opened. And also there are some family support workers that are still continuing to work during the current restrictions. And so I think it's about, when thinking about Part 25 applications, parenting assessments and expert assessments, really thinking about what the proposals are, what work, if any, can be undertaken now. If work is going to be undertaken, the medium that's going to be undertaken, whether it's audio or video calls or assessments in local authority offices, however that could be put in place. But I do think there needs to be careful consideration to the timescales and whether we need to extend the timescales, because I think the real potential problems being lined up for once the cases that are starting now, commencing now, are going to be heard at final hearing when we find that actually no one really accepts the outcome of assessments that have been undertaken with the current restrictions. So I don't have anything further to add, save to say, as we were going through the talk, there's been a recent decision, I think Rebekah shared it, of REQ, which was a decision from the president about adjourning a hearing, or whether a hearing ought to go ahead remotely. It's a private law hearing, but what he says is, and it's interesting as we're talking about the sort of rowing back perhaps of, or the interpretation of REP. And what the president says at paragraph 33 of that judgment is that although this was an appeal from a district judge, wouldn't normally get heard by the president, it came to him because of REP, because of the application of REP. And what he says, the last sentence of paragraph 33 is, the decision in REP is expressly tied to a small number of cases in which allegations of FII are made. Paragraph 24 in REP is more general, obiter application, and the judge was correct in referring to it. So again, I think we're in a very fast-moving situation where we've got daily decisions about remote hearings and how they're being conducted, and it's really a question of keeping on top. And the President has said that's a decision that he wants all practitioners to be familiar with. So thank you very much.